do you need to come back, right? It was working fine. Why? And micromanagers are like, I need to literally watch you. You got to understand the environment and see if there's something you can do. Self-reflect yourself. Studies shows it, and if you Google whitening resume, a lot of people are concerned about it. There are people that are saying it's slacking off, don't do it. And there are people who are saying, you know what? Why would I go above and beyond, right? It's more like I'm going to go somewhere that I am celebrated.
Hello, how are you?
Hi, David. Well, thank you so much for coming in. For those of you who do not know us, I am Sweta Regmi. And please let me know if you can hear me. Give me thumbs up on audio event. People who are watching us, listening to us right now, please let me know that. Give me a thumbs up. I'm streaming this on YouTube Live as well. This is Sweta Regmi. I am a founder and CEO at Teach Hindu, and I'm a certified career strategist and resume strategist as well. So I've hired a lot of people in the industry before. I was a hiring manager in top bank, and I've had to go with situations such as layoff, terminations, and so much in my personal lives. And also, I was impacted by layoff as well. After working there for more than 10 years, and within 1 minute, I was gone. And I think there are so many eye-openers for myself as well to take a look at it from the legal perspective. And that's when I reach out to see if I can get some legal advice. So now what you can do is you can ask questions to David as well if you are impacted by a layoff, or if you're thinking that you might be on that boat soon. Today, we're going to go over some strategies, and we're going to take questions as well. David Khan is an employment lawyer based out in Toronto, Ontario, in Canada. And he's going to go over, first of all, I'm going to ask you questions as well. So, and then the audience could come in and ask questions specifically. Let's stick with the layoff. Any questions regarding to the layoff for the audience, if you want to come up on the stage. David, why don't you introduce us? How long you've been doing this in Canada for?
Well, I've been in practice for 29 years. I articled with a management labor firm, and I've done a great deal of employment law over that period of time. And my practice also includes, labor work as well, and litigation. So by layoff, are you also meaning termination as well? Like somebody who's their employment is completely severed by the employer?
We can talk about that. That's probably the second stage. And today, let's focus on layoff, because I know for those who want to know about the employment law in Canada, David and I normally do this regularly. I do have that on YouTube channel as well, Teach Hindu. You can go and see all sort of employment law in Canada on a high level. It's on my YouTube channel as well. So David, first of all, let's go dive right into it. I have my questions ready. You know, when you get the layoff package from the employer, obviously you don't have a time to look into it, everything. So basically the normal process that I've gone through as well personally was I was laid off over the phone because I was working from home. But in the event that, whatever happens, you're at the office and you get laid off, you have no clue normally. And then they will call you, they will have a meeting in a calendar. Sometimes it's just like, you know what, okay, let's chat. And then the HR is going to be there, and HR is going to break that news. Your roles is, it's eliminated. It's going to be very, very short and sweet. And HR takes it over, goes over with, okay, these are the severance package for you. If you have any questions, here's a direct, email or whatever it is. There's a contact person provided on it. Now, I understand, David, there is the time limit on it, right? So they will say you have to sign this severance package by a certain date. What are your thoughts on it? Because people panic and people are like, okay, I have to sign this. I don't have a time for it. So employer, let's go one by one. As an employer, how long of what should be that period? What does that period look like? What is illegal and what is legal? And from the employee perspective, do you have to abide by that, terms, which is you have to sign this within a couple of weeks? What are your thoughts on it? Let's walk our audience and listener over.
Okay, so an employer has sat down the employee and has said, we're terminating your employment, correct?
Yeah, which is obviously your role is eliminated. It's without the cause. Let's just focus on layoff. So it's without the
Okay,
cause. All
without
of a
cause.
sudden, it's like layoff. You know how when the layoff happens, they don't actually talk about performance, anything. It's just like roles eliminated, right? So let's focus on that. Yeah.
Yeah, so an employer should not require you to make a decision on the spot, and most employers will not do that. So they won't say you have to sign this right here. So what's reasonable is a couple of weeks, I think. My experience has been that if an employer puts a deadline, let's say, for example, today being February the 3rd, they terminate somebody today and they say, well, we need a response by February 18th. I've always found if you contact the employer and say, look, they're reviewing their legal options, no employer has said, no, we need a response by February the 18th, because an employer does not want to be in a position where they've kind of pressured an employee to sign a termination package. So really a couple of weeks is reasonable. And that should give you an opportunity to seek employment advice from a lawyer and decide on your options. So certainly not on the spot, but a couple of weeks is typically the norm. And again, if you need more time, I've usually found employers don't have a problem with that.
Okay. Now, question for you. Let me take it from there. So what if employee do not communicate and they're late on signing that? So how does that work now? So they're like, you know what, I'm not going to sign it. I'm still looking for it. I don't want to tell them that, I'm looking for legal guidance, but I have to meet this deadline. So where does one go from there? So is it going to be all void, the severance, or do they still have the right to go back after the deadline ends?
Well, typically the employer wants you to accept that package, okay? If they're offering you a certain amount of weeks, and of course it's got to be above employment standards, or at least meet employment standards. If they're offering you that, they typically want you to accept that. So if the deadline comes and goes, if they say, look, we need a response by February 20th and you don't respond, my experience is the employer will say, look, this offer's still open. Are you going to accept it? So again, that's because they want you to accept that, right? Typically, this is what they think is fair, and they want you to accept it. So it's not usually a big problem. You have to look at a couple of things. First of all, the first thing the employer should determine is whether or not there's a written employment contract. Okay?
Mm-hmm.
If there's a written employment contract, that may contain a termination clause. And that termination clause will say what you're entitled to if you're terminated without cause. So, for example, a lot of employers want it to be that you're only entitled to employment standards minimum. And that's the standards that are set out in statutory legislation, for example, the Employment Standards Act 2000. So that will limit you to termination pay and severance pay under the Employment Standards Act. It's possible, however, you've signed an employment contract that says, look, if you're terminated, we're going to give you X amount of notice. So that's the first thing you have to determine. Is your termination governed by a written employment contract?
That's a great point, because I think you were one step ahead of me, because I did have that question in it. No, that's fine. That gives us good segue into it. So a lot of people a lot of people, including myself as well, when I got laid off, I had no idea the job offer that I signed it's extremely important to go and see your employment contract. So the job offer is really crucial. So anyone right now, any jobs that you've signed it, even let's say you got promoted and you have more responsibilities, whatever it is, always make sure you ask for the new contract, new job offers. Anything that changes, you got to make sure that you talk about it and it's on an employment contract, because what happened 10 years ago and then you were, let's say, moved on and assigned the more responsibility, this is why you need to update your contract as well. And then the last one you signed it would be the one that you would be looking into it when it comes to layoff package. Am I right in assuming that, David?
Yes, that's a very good point, actually. What often happens with long-term employees is that they're terminated without cause, and the notice provision is something that's not a lot of notice that might have been appropriate 10 years earlier, but isn't appropriate now. And the employer says, well, sorry, 10 years ago, you signed this contract saying we would give you employment standards plus 2 weeks. And there is a way around that. You can claim that the substratum of the contract has disappeared. In other words, the termination clause shouldn't apply now because your job duties have changed significantly over that time, your salary has increased, et cetera, et cetera. So it's possible that the termination clause may not be valid. However, that requires litigation, which you want to avoid really if you can. Because
In a
it's
plain
expensive.
term, when you say litigation, what does that mean to the listener? Can you tell them like what exactly
Yeah.
that means? What
That
the
means you have to
process?
sue your employer. You have to commence a legal action against your employer in court and say, hey, guess what? This termination clause really shouldn't apply to me because, when I signed this agreement 10 years ago, I had a whole different job. So you're already in the forum where you've got to commence an action. So the best step, as you said, is when you get a job, when you're offered a job, you want to review that employment contract and you want to make certain that you look at the termination clause. Because a lot of employees obviously don't want to step on their employer's toes when they first start and say, hey, I want more notice. But it's something that has to be viewed at the time of hire.
And this is what I think a lot of people like. I know that a lot of leadership, people in the leadership role, executive committee, they have their own lawyer. Whenever they get the job offer, they would actually go and then see what are the contract, what they can negotiate. So the negotiation, this is why the negotiation at the time of offer is really important for you to go and then dictate how you want to have that exit plan, because a lot of people miss that and it's too late. Now, question for you. Let's go back to non-compete clause that just literally just happened. So tell us about if somebody had signed that non-compete clause, what does that mean from the legal perspective to the employee? How does that happen now? It's been illegal in certain provinces. So walk us through what should people watch out for when it comes to non-compete clause on the job offer. What does that mean to individual? Yeah, but you're on mute, just so you know. David, I can't hear you, so you're on a mute, so I'm not sure. Do you want to come back, log out and come back again? You can try from phone as well. Sometimes it just glitches, so I'm not sure. Okay,
Can you
now
hear
you're
me
back.
now?
Yes.
Okay. So there's two clauses you have to be aware of really in a contract. One is a non-compete that you refer to, and one is a non-solicitation. Courts have always had a problem with non-compete clauses because basically that's saying you won't compete against your employer. And courts do not want to stop you from earning a living. So those clauses have been suspect for quite a long time. A non-solicit, however, is something different, and it's typically enforceable. A non-solicit clause is when you say, you know what, we don't want you after we terminate you. We don't want you approaching our clients and our customers and saying, hey, I've set up my own company now. Why don't you come to me? That's probably likely to be more enforceable than a non-compete that says you cannot set up, you cannot compete with us. So that's now been put into the Employment Standards Act about an employee is not required to sign a non-compete. Now there's one important exception, and that's in the sale of a business situation. So somebody purchasing a business, it's completely valid that the vendor will agree not to compete with them, because what would be the point of buying their business if they're going to continue to compete? So, but in an employment setting, a non-compete clause likely might not be enforceable.
Okay, and then there's a new law in place that employers are not allowed to actually add that in. Walk us through that.
Yeah, that's in the Employment Standards Act. You'll find that if you're an employee for which the Employment Standards Act applies, i.e. you're in Ontario and you're not federally regulated, then now they've put into place something that says that you're not required to sign a non-compete.
Right, and then what happened? When did that happen? So what happens to the people who had signed that before? Does that make it like irrelevant, or would that still stay for the people who?
Well, that's a good question. Typically, we get into the issue of, well, is it valid in any event? Because the reason for that sort of legislation is that these non-competition clauses were not being upheld because they're preventing people from earning a living.
Perfect. Okay, so now for those of you who don't understand the non-compete clause, which is, let's say I work for the bank and then I got laid off and my employment contract says that I cannot actually go and then work with the other bank. Now that just eliminates everything if I want to go back to the banking industry, right? That's why it's not fair. Yeah. And that's why. Yeah. And then you also say on a contract is, okay, you cannot even solicit my employee. So you cannot tell people, let's say you're a hiring manager, that happens, and you want wanted to hire some people that you already know, you want to build your tribe in a new company, you're not supposed to solicit. Normally you would have a terms like one couple of years, months or something like that. So, I mean, I'm not worried about the second one, which is valid, but I'm really worried about the first one, which is non-compete clause. And if you have it right now in Ontario, it's not valid. You got to speak up on it. And then if it's happening somewhere else, negotiate it, because that's going to dictate the layoff package later on, and you're out. Like, you have to literally, even if you have a really good offer, you can't do it. And I've seen that in a lot of industry. So now, next question for you, David, is here's the thing that employers it's happening right now. Tell me more on this one. And I know this has been ritual for employers. So whenever there's a fiscal year, like calendar year, depending on it, after Christmas, the bonuses are due normally, and people in the management, they make a lot of money. They actually look forward to the bonus, right? Because they're meeting KPIs, meet and exceed, and they're like, we're talking about tens of thousands of dollars. And people who are making bonus. And then I've seen the trend from the employers in the past was, you're done, like you're laid off today, the bonus payout is probably due tomorrow or next month or third month, like you're supposed to be waiting for it. But now, you know what? Do you get that? Should you negotiate on that, or employers should be mandatory, going ahead and paying that bonus when the bonus payouts happens, right? What happens in that case?
Well, the first step is, when you terminate the employee, you have to determine what the appropriate notice period is. And let's say the appropriate notice period is 12 months. Any employment income they earn during that 12-month period, they should be entitled to, including a bonus. So what has happened is, employers have placed clauses in their employment contracts that say, hey, you have to be employed on the day that the bonus comes due, or you're not entitled to your bonus.
There you go. I'm going to stop you right there. And that was my next question for you. And for a lot of people, you don't understand the term. This is dictated on job offer. If you see the job offer, most of the job offers are standard, and it says for you to get any benefit, any bonus, anything, you got to be actively employed. Is that what you're referring to, David?
Yes.
Okay.
Yes.
So go on. So what happens? Now they're not employed. Now they're supposed to be waiting for the bonus. And let's say notice period is 12 months. Let's say you're paid severance for more than now you're getting the severance. You're still on a payroll actively with them, but then you're not employed. Should they be getting a bonus?
They probably should, because these cases have gone to the Ontario Court of Appeal. In fact, they've also gone to the Supreme Court of Canada. And what's happened is there's kind of a two-part test. The first thing they say is, what's the appropriate notice, and would the employee have been entitled to a bonus during that notice period for the 12-month period? Then the second question is key. Do the terms of the bonus plan or the employment contract unambiguously take away that right, that common law right? In other words, it has to be clearly set out in the employment contract or the bonus plan that you won't be entitled to a bonus if we terminate you and your bonus is due in a month. Now, it's not good enough to say you have to be employed on this date. That won't relieve the obligation, because what the courts are really concerned about is they want to make certain that, for example, if you had been employed for that 12-month period rather than terminated, you would have gotten that bonus.
That's right. And the benefit too. Anything
Exactly.
that includes, including any benefits you are entitled as an employee. It's not only bonus, guys. Listen to this very carefully. Go on.
That's right. So anything that you would have gotten during your 12 months of notice would be captured. So obviously your employment, your bonus, any kind of benefits, any sort of perks you had. Typically the courts will say, okay, that's what you're entitled to. That's what a terminated employee is entitled to. Now, is there anything in their contract or bonus plan that takes that away, that clearly says, by the way, you're not getting this? And that's why a lot of these cases have been upheld, entitling employees to their bonus, because the language is not clear and unambiguous.
Now, question for you. Let me take that away. Let's say the severance is not paid until 12 months, right? And we're going to go with the severance calculations, like rule of thumb, right? It's not one size fits all, obviously, but I want you to go over high level how the severance normally are calculated. Now, let's go with this scenario where the person is not paid, like the bonus is not due, let's say in today or tomorrow, it's due in 3 months, the severance is like paid up till 3 months, right? So are they still like that bonus is based on the last year's, right? So let's give example to be very clear. So I'm working there from like, January to December, entire year. My bonus was due for that year, and I got laid off. And, next, let's say February, which is this February, let's say, right now I got laid off. Now I know that I went through the performance review. I know the bonus was, I was eligible for bonus. I already know I'm waiting for that. Now I'm gone. So now what happens is, let's forget about the severance. Let's say, am I able to go back and negotiate on it? Okay, well, where's my bonus? Because I earned the bonus. Let's say employment, severance is not like, let's say the severance is up to like 3 months or something, right? Like, let's say I'm not on the active payroll. Let's say I want to take the lump sum payment instead of being active payroll, because that's a negotiation as well. Am I entitled to ethically earn that bonus the right way?
So Swati, are you saying that, for example, if you're terminated, you're entitled to 3 months of notice, and your bonus would have become due 5 months later?
Yes.
You get the bonus,
you know how employers pay bonus not right after? They will hold on to it. The bonus is not even paid in 3 months. That's a good point. Thanks for clarifying that. Yeah. So would I be still eligible for that?
Well, I would argue that you would. I would say that, look, you earned the bonus while you were employed. But you do get into a sticky situation if the bonus is to be paid, let's say 6 months after, and you're entitled to 3 months of notice. That's a bit of a gray area. However, the argument I would make is that, well, you've earned that. The employer has obtained a benefit. There's been a deprivation to you because they're not paying the bonus, and you should get that. But that's a little trickier. Typically, what courts will start with is, what is the appropriate amount of notice for this employee? And that may be different from what the employer actually gives you. To give you an example, let's say the employment contract does not have a termination clause. Let's say it's completely silent on what you get when you're terminated without cause. There's just not a clause in there, and that's not uncommon. Then it's governed by common law factors. Common law factors being your age, your length of service, your job responsibilities, your salary, all sorts of factors.
That's what I want you to walk you over. So let's go over how normally the severance is standard, like, how is it calculated high level? Can you walk us through?
Well, typically what will happen, let's say the employer says, well, you know what, we think you're entitled to 6 months. You've been here for 8 years, and we're going to give you 6 months. And the court may say, if the person sues, the court may say, well, no, that's not quite right. We think based on all the factors, you're entitled to 9 months or 10 months of notice. So it's not unusual. An employer will try and maybe lowball an employee because, there's a possibility an employer will find another job and mitigate himself out of any damages. But once you get into that scenario, again, you're in litigation. You have to sue your employer if you think you're entitled to more notice, and then you have to decide, is it worthwhile for me to spend 2 or 3 years suing my employer so I can get, 3 or 4 months of notice additionally? Now, that may be a big deal if there's a big bonus at the end of that, right? If that, for example, if you would have gotten the bonus if you've been employed 9 months and the bonus is $100,000, that may be worthwhile pursuing.
So you have to weigh it out. Is it supposed, how much are you thinking about when it comes to the legal costs, like high level, let's say? What are you like? What are the things that people should look for when hiring the lawyer? There's a contingency aspect. There's an hourly aspect. How does that work for people who are thinking of hiring a lawyer?
That's right. There's a lot of employment lawyers who will do the case on contingency. In other words, they'll only get paid if you get paid, and that can be very advantageous for you if you're terminated and you don't have a great deal of income to put towards litigation, because it can take a few years. So certainly that is becoming an increasing trend, and it certainly has a benefit if there's a lot of money, or if there's a significant portion of money to be recovered.
What are we talking about in terms of that? What's a percentage we're talking about? Can you give us an example of it? Like 25%, 30% of the money that you actually get it back from the employer?
Well, I don't do contingency, but I would think that 25% would be reasonable. Yes.
And what are we talking about, like when it comes to hourly, the range? I'm not asking your rate, ranges of hours, ranges that people should be looking for when.
Well, an experienced employment lawyer can be charging you anywhere between $300 and $600, $700 an hour. And to take that to trial. And typically you don't want a case that's just concerning notice to go to trial. You don't want the employee to say, well, I think I'm entitled to X amount of notice, and the employer to say, well, you're entitled to Y, and then spend 3 years in litigation and actually have a trial on that issue. And there's a couple of ways that you prevent that. And one method is through a mandatory mediation. And that's a requirement that if you bring a wrongful dismissal action, that you have to attend a mediation. That's before a neutral party who will try and help you settle it, because these cases should be settled. They shouldn't be litigated unless there's significant sums at stake.
All right, I have a question in TikTok, and it says, I was terminated during my probation without any reason. Is that okay? Would it be factor into like terminations, or would it be, can employer lay you off? Like, would it be, do they still have to give you severance?
Well, what typically happens is this. You will see in a lot of employment contracts, there'll be a probationary period, okay? And that period is typically 3 months, or it can be 6 months, and it will contain something. The employer will say, well, you know what? If we terminate you during the probationary period, we don't have to provide you with any notice.
What if it doesn't say that in there?
Well, under the Employment Standards Act, your entitlements to notice kick in after 3 months. So if you're there 2 months, you probably aren't entitled to something.
Okay.
One caveat I would say, though, is a scenario. It doesn't come up every day, but there's a scenario where somebody's gainfully employed with a company, okay, and an employer approaches them and says, we'd like you to work for us, and we're going to offer you a decent package. So they leave secure employment, they go to the new employer, then the new employer says to them after a couple of months, it's not working out. Well, you maybe have a cause of action to say, hey, you kind of lured me away from secure employment. Okay, I could have still been happily at this job. Again, that's litigation, and again, cases can go either way. But in terms of a probationary period, you may be out of luck if you've just been there a couple of months and you've signed a contract that says, hey, we can terminate you after a couple of months.
Now, one question that I've seen and I've heard as well. So let's say, in that case, example right there, it has happened. I've seen it. So employer recruited the leader, someone on the leadership team.
Yes.
And then they did the negotiation at the time of signing the offer, and they did this thing called, sign back bonus, right? That there are persons supposed to get that bonus, not like one-time pay. So for every year, let's say the person's supposed to get the signing back bonus, yes. Certain percentage, whatever it is, or like it was a flat amount, right? Between that time frame, the person was gone. Now, the employer did not include that in the layoff, right? So now, do you have a right to go back? Hey, we agreed to this. I was supposed to be employed. I was supposed to get a sign back bonus on it. And now I'm not there. I still have to get that because that was dictated in a contract. Can people ask for that?
Well, yeah, it depends on the terms of the contract. If there's something in the contract, yes. But otherwise, what you're basically basing it on is what are your entitlements during that reasonable notice period.
Okay, so like as long you do have an option to go back and negotiate and see where it's coming from because it was negotiated at the time of job offer. And this is why a lot of people, executive leadership, they actually go through the contract when signing the job offer. And these are really a key point for you to negotiate and not take it, except the severance package, because you have no idea. And that's why you have no idea. There's a clawback as well. Can we talk about, this is the legal thing that I know of because I've worked through it. I've seen my clients because I work with a lot of layoff survivors and I understand these terms. What does clawback mean to you and why does it affect you? Can you walk us?
Well, where I encounter a clawback is typically when somebody's terminated and the employer does not give them a lump sum. Okay, they may say, well, you know what? We think you're entitled to 10 months of notice. We're not going to give you a check representing 10 months of notice, and then you can get another job in a month. What they'll say is we'll give you 10 months of salary continuance. So in other words, if you're still not working 10 months later, we'll continue to pay you up to 10 months. However, if you secure a job after 4 months, we'll say, you have to pay us 50% of what we would be. We're not going to give you it all. So there's a clawback in that sense.
Or you would forfeit, like you would not get any severance from us, or you would get 50% or something. So can that be negotiated from the employee perspective?
Well, keep in mind if an employee is terminated, okay, and that let's say they're entitled to 6 months of notice. If they get a job after 3 months at comparable employment, they've mitigated themselves out of a lot of damages. In other words, they've secured a similar job, we'll say at a similar salary. They don't really have a cause of action against their employer because they've gone ahead and mitigated. Now, typically, that doesn't always happen. Obviously, if somebody is entitled to 6 months of notice, they don't necessarily find a position or a suitable position in that time. So there may still be damages. But anybody claiming a breach of contract, and that's a terminated employee, has an obligation to mitigate their damages by finding alternate employment.
Okay. And the other question that I have is people on a leave of absence. That includes the short-term leave, mat leave, long-term leave. Can employer eliminate their role?
That's very dangerous, because if they do that, they may have committed a reprisal under the Employment Standards Act when somebody's exercising their right to a leave. And you used to see this when the leave was typically what people refer to as mat leave. And the woman would be terminated when she advised them that she was leaving on mat leave, or was terminated upon her return. And that was the initial protections. But that's, as you know, if you look at the Employment Standards Act, that's been applied now to, there's like a dozen different types of leave. So yeah, an employer has to be very careful when they're terminating somebody on leave, because they may be committing a reprisal. Also, if the person's off on leave due to illness and you terminate them, you're probably running afoul of the Ontario Human Rights Code.
So that falls in the human rights codes.
Well, it depends. It depends. As I say, you'd have to fall under an enumerated category in the code, but one would, of course, be if you're off on a long-term illness or any type of illness that would be considered to be a disability.
Mm-hmm.
Then
how
an
long?
employer has.
How long do they have to, let's say, David, how long do they have to protect their job? Let's say the long-term leave or short-term leave, like normally short-term leave is like 3 months, right? Long-term leave, it could be ongoing. So how long the employer would have to protect the job?
The employer has to wait a long time, Sweater, because, there are cases where somebody goes off on illness, and first they're on short-term disability, as you said, and then they're on long-term disability. So they're covered by their insurer. Eventually, there will become a point where the contract will be frustrated. In other words, the employee cannot perform the duties of the job and the contract's at an end. But that can be a couple of years in Ontario. And so most employers are not going to terminate somebody when they're on disability leave.
And question for you, does it matter if you have if you have union, or does it matter if you don't have a union? Would the law apply to both? How does that matter? Would the union collective bargaining agreement would dictate that?
Yes, it matters a great deal. What we've been talking about is non-union employees.
Right.
So your right to wrongful dismissal, to proceeding in an action in a civil court like the Ontario Superior Court, that's for a non-unionized employee. If you're a unionized employee, you're covered by a collective agreement.
Would it disclose it in there, David? Let's say the union job descriptions, like, job offer, you sign it, it does not disclose it. Should it, what if it does not disclose it that if you go away on a leave, this is how much your job's protected? What are your rights as an employee if they lay you off or the role is eliminated?
Well, you have a number of rights as a unionized employee. In fact, you enjoy a greater benefit, is that the union will advocate on your behalf, and if necessary, hire legal counsel on your behalf. And that will be dictated by the terms of the collective agreement. And also, of course, the Employment Standards Act, a number of provisions apply to unionized employees. The difference is that if you're terminated in a unionized setting, your union will file a grievance on your behalf under the collective agreement.
Okay, and then these are the things that normally you guys don't take it, right? You don't take it from, let's say if someone is in working in the unionized department, it's completely different. So they are the one who's going to fight for you because you're paying them, right?
That's correct. I mean, I've had obviously union employees approach employment lawyers, and I said, look, you're governed by collective agreement, and your union will file a grievance on your behalf and carry this to arbitration if necessary. Now, some employees are not happy with the representation that they get from their union. Those are tough cases. Then you're at the labor board, but typically you've got to use the process set out in the collective agreement.
So we're talking about labor board. If someone wants to fight it, they're not happy with the union, then they have a right to
labor board. Yeah.
So there is a resolutions which is escalating to the union board, labor board.
Yeah, here's the problem with the sort of duty of fair representation that a union has. Typically, the labor board's remedies are very limited. We're not talking about damages. We're talking about them saying to the union, we order you to take this case to arbitration. And typically, that's very hard because the union will say, look, we got a legal opinion, and we think this grievance isn't going to succeed, and we don't have to take it to arbitration. If we've looked at it, we've taken an investigation. Not every case is a winner, right? And a union can decide, look, we're not going to advance your case. But I mean, that's worst case scenario. Typically, if you've been at a company for several years and you're terminated, leaving aside the layoff provisions in the collective agreement, if you're outright terminated for some reason, your union should be advocating on your behalf.
Right. Now, the last question before I take a question from the stage, I'm going to invite you to stay on the layoff only, especially if you're in Canada. So I'm going to ask you a last question. So I've seen this a lot when I'm working with the clients, when I'm looking at it, when I'm interviewing them. Constructive dismissal. Can you walk us through what exactly it is from the legal perspective, and what are the red flags, and when you should go back and start documenting and fight back?
Yeah, basically, constructive dismissal differs from an outright termination. Obviously, if an employer says, look, you're terminated, here's your package, that's pretty clear. A constructive dismissal isn't necessarily that way. And typically what happens, it's when there's a fundamental sort of a unilateral change in your employment contract that you don't condone. And these cases have gone to the Supreme Court of Canada as well. So typically, I mean, a basic constructive dismissal, I'll give you an example. If you're being paid $100,000 a year and your employer says to you, guess what, starting in January, we're going to start paying you $75,000 a year. Well, that's a pretty clear case of constructive dismissal. In other words, your employment contract has unilaterally been altered by your employer. But it can take subtler forms. It can take the form, and the Supreme Court of Canada has weighed in on this. If the employer treats the contract as being at an end, and this can be if they treat you in an abusive fashion, it's possible that there's been a constructive dismissal. Here's the danger, though, with the constructive dismissal. An employee may think they've been constructively dismissed. They may think, well, you know what, the contract's at an end. This is like a breach of the contract. But a court may think otherwise. They may say, well, you know what, you might have thought that, but we just don't think it meets really the constructive dismissal. So it's a harder case. It's a harder case to make it litigation, but it's certainly it's a growing type of case. It's very prevalent in the workplace, and it's something that you should always be aware of.
Right. And a couple of examples that when I'm working with the client, when they hire me after they got laid off, listening to the story, a couple of red flags that I have identified when it comes to constructive dismissal, they don't understand. So what starts to happen is you're just like the way you said it, right? You are hired for specific needs. And then all of a sudden what happens is your responsibility is changing. You're getting less amount of project, less amount of work, and then if you had a direct report before, now you no longer have a direct report, right? You don't have to manage any employee. You're putting yourself from the leadership role to individual contributor. The next step is now it's slow. The work is slow. So it's almost making it look like, listen, I don't think we need you anymore without telling them. You feel it to manage you out, and literally later on saying that I don't think we're like, you're needed here, right? So you got to watch out. This is why anytime the responsibility changes, and people are happy sometimes thinking, oh, I don't have much responsibility, I'm so good at it, right? But I want you to think of it. Why are they changing it? Anytime that changes, anytime you add on more on it, it's always best to have a new employment contract and document it and speak up, because when you go to people like David, what is it that you're going to ask David? The email communications, the documentation, HR meeting, and then if let's say they cannot even do it, you can add the things for things, which is you can ask the employer to pull the emails, which is called what in legal language, subpoena.
What's that? You're talking about?
So let's say,
what
if in the event that you feel that your responsibility is been diminishing or changing, whatever it is, and you've spoken up and there's back and forth documentation, emails, and now employer's not there. A lot of people say that I've talked about this and I don't have a proof for it, but that's your proof. So let's say you as a lawyer, someone comes to you and say, I got laid off and I feel like it was a constructive dismissal. It was retaliations. I have a proof, but I don't have it with me. It was all recorded on the email back and forth. So as a lawyer, you'd be going to the employer and asking for a thing called subpoena, right?
Well, yes. In terms of a summons, yes. Subpoena the documents. Yeah, that's correct.
Tell us, what does that mean from the legal perspective? Because a lot of people don't know that you guys can ask that to pull the documentations. What does that really mean? And why should people document it?
Well, this is typically how you get documents. So in a case, once you've commenced an action against your employer in Ontario, you fall under the rules of civil procedure. And there's a requirement that each party produce all relevant documents that are not privileged. And so what happens is the parties exchange affidavits of documents which contain all these documents. Now, it may be, to use your example, Sweta, let's say the employee says, well, wait a second, there's a lot more emails that we talked about. They're not in the employer's productions. Well, you can request those emails at discoveries when you examine the employer's representative. And you can bring steps in the court to obtain relevant documents if they're not there. And typically, as I say, there's an obligation on a party in litigation to produce all relevant documents. They can't hide these or lay in the weeds with them for trial because they might not be able to rely on them if they do so. So there is supposed to be full documented disclosure, and hopefully you will get those documents when that occurs.
Okay, one last question that I've been hearing it and someone was saying it. I'm not sure. What are your thoughts on it? So if you want to hire a lawyer, let's say when you get the severance package, should you give heads up to the employer or should you not? Because my understanding is if you get the heads up, they're going to be on top of it and they're going to have a full house of lawyer, right? So what do you suggest?
No, typically what happens is if somebody comes to me with an employment package, they've been offered by their employer when they were terminated, I'll write a letter to the employer and say, look, I've been retained by so-and-so. You terminated them on such a date and you're offering them this. And I'll have what I call a shopping list letter where it's not confrontational. I'm not saying we're going to see you in court and all that. I just say, look, this is what I think my client needs to settle. Okay, and of course it will be more notice, more of this. And there'll be a list of things that I require, and that will be sent to the employer. So they're put on notice that the employee has an employer, and they're not going to, a lawyer. They're not going to have a problem with that. The vast majority of employers are going to understand that you're going to seek legal advice. In fact, typically the release that they'll put in front of you, and maybe we should talk about this too, in terms of a release. Mm-hmm. If you sign a release, what you're saying is you're barring yourself from bringing any claim against your employer. Mm-hmm. And typically what a release will contain a clause that will say, look, I've had the opportunity to seek independent legal advice. And I did that or I waived that right. So that's very important to the employer too, because they don't want somebody coming around later and saying, look, you never told this person to go speak to a lawyer about this.
Mm-hmm. That's a great point. Now, anyone has any questions up on the stage, raise your hand. David can answer that question for you. I'm just going to stay here for a couple of minutes. And before I do that, I just want to let you know that I'm offering the free masterclass for resume on February the 10th at 7 p.m. There's a link I'm sharing on my YouTube channel. You can go ahead and click it. And then you can go onto my profile. When you go at the bottom, you will see the free resume class registration link is on this link as well. Go ahead and sign up. There's a limited list of people I'm going to go and then do this. So if you're laid off, I'm going to cover that as well. How do you communicate that on a resume? How do you talk about this in a career break as well? Because you are going to have that career break as well, right? I'm going to go through a few strategies. Go ahead and sign up. And if you have any questions about the class, it's free. So come in and ask me questions. you can join me, and then also message me if you want to know more about this class as well on LinkedIn. So anyone coming up here for the question? So I don't think there's any questions here. Anyone from stage? Let me know if you have any questions. Let me see if there's anyone who is asking me questions on TikTok. TikTok, can you let me know if you have any questions? Let me see. I'm going through it. We've already answered one question here. I got laid off in December. The job market seems to be okay. Could you let me see here? Okay, not much about the layoff on TikTok, but I think there's no questions. There are a lot of questions before, but I think people have left. But thank you so much for coming in, David. I appreciate it.
Thank you as usual. I appreciate it.
All right. Thank you, everyone, for coming in my audio show. I do this every Friday at 11 a.m. Eastern Standard Time. I have next live coming up with a resume writer who's going to go through, we're going to go through how do you go about communicating the career break or career changes, pivoting. Go ahead and subscribe to my YouTube channel. It's on my file as well, on my profile as well. So that way you can catch the replay. Thank you so much for coming in, everybody. And 1, 2, 3, I am out. Thanks, David.
Thanks, Sweta. Thanks, everyone.
Bye.
Bye.
All right, guys, I'm leaving here. Bye-bye. Hi,